to human life. The jury never made that finding. In fact, the jury was never instructed that they were required to make that finding. The jury also never knew that the law didn't require them to deliberate endlessly on Tremane's punishment until they reached a unanimous decision. Otherwise, they wouldn't be allowed to go home. And we know that had the jury been properly instructed, at least one juror, Gira Burton, the only black person on Tremane's jury, would have voted to spare Tremane's life. Ms. Burton testified to as much before the Oklahoma House of Representatives Criminal Justice Committee, which held a felony murder interim study last fall. One vote is all that was needed for Tremane to receive a life sentence. Ms. Burton also testified before the Oklahoma legislature that she has been haunted for the last 21 years by the fact that she wasn't properly informed at Tremane's trial that she could stand by her personal moral conviction, which she held at the time, that Tremane did not deserve the death penalty. That moral conviction has never left Ms. Burton, and it's what brings her here today to stand up for the value of Tremane's life. Quote, death penalty cases require the highest standard of reliability. The greatest exercise of state sovereignty is the state executing another human. To execute a man whose trial conviction was impugned by a litany of errors, no execution should be carried out under such questionable circumstances. End quote. Those are the words of Attorney General Gentner Drummond when he stood before this board 2 years ago to petition for mercy for Richard Glossip. It wasn't about the number of write-ups or the mistakes or the lapses in good judgment that a person had made over their decades incarcerated on death row. It wasn't about a person's cell phones or drug activity or gang associations, issues which we know are real systemic challenges across prisons that ODOC is actively working to craft rehabilitative solutions to. Rather, it was about whether the trial resulting in a death sentence was, quote, impugned by a litany of errors, end quote. And that criteria applies to Tremane too. There is no question that tragedy abounds in this case. Executing Tremane, however, will only deepen that tragedy. That's especially so where the victims in this case, Ronnie Whipp's mom, Barbara Whipp, and Arnold Kleinsasser, don't want Tremane to be executed. In fact, as recently as this past Saturday, they have been publicly speaking up for the value of Tremane's life, despite the pain that he's caused them, and they're publicly opposing his execution. The compassion and the mercy that the victims in this case have extended to Tremane, rooted in their life-affirming Christian values and in their recognition that we have all fallen short, is nothing short of transformative. Mrs. Whipp and Arnold are showing Tremane, and in fact are showing all of us, that even when irreparable harm has been inflicted, there is a path forward beyond vengeance. A path forward that is instead paved by forgiveness, by compassion, and by mercy. This board has said that, quote, a commutation is intended to correct an unjust or excessive sentence. The evidence here is overwhelming that Tremane's death sentence is the direct product of fractures within our criminal justice system that render his execution and his death sentence fundamentally unjust. That evidence just keeps piling up. Earlier this year, we unearthed evidence proving that trial prosecutors Fern Smith and George Burnett, who won Tremane's death sentence, did so by concealing from Tremane's jury the benefits that their witnesses were getting in exchange for their testimony. The prosecution's key witness against Tremane was his co-defendant, Brandy Warden. At the time of Tremane's trial, prosecutors told the jury that their plea agreement with Brandy meant that she was going to spend 45 years in prison, half her life incarcerated, they said, in exchange for her testimony against Tremane. At the evidentiary hearing, trial prosecutor George Burnett revealed for the first time on the stand under oath that the prosecutor's actual deal with Brandy was not in the written plea agreement. Rather, their actual deal with her was in a cooperation memorandum. No one had ever seen this cooperation memorandum before, and so Judge Susan Stallings, who was presiding over the evidentiary hearing, called a recess, and she obtained a copy of the cooperation memorandum from Brandy's attorney-client file at the Oklahoma County Public Defender's Office. That agreement shows that contrary to what the prosecutors told Tremane's jury, Brandy was actually promised a 35-year sentence in exchange for her testimony, which is exactly what she received. The prosecutor's fulfillment of that promise to Brandy, moreover, required them to ensure that her pending deferred sentence for committing a prior felony in Payne County was also dismissed and expunged 6 months before she took the stand on behalf of the prosecution at Tremane's death penalty trial the following spring. The reason that the Payne County prosecutor gave for dismissing and expunging Brandy's deferred felony was that she had, quote, satisfactorily completed the terms of her probation, end quote. That is despite the fact that this same prosecutor testified at the evidentiary hearing that he was aware at the time he made that representation that it was false. Brandy had in fact violated the terms of her probation in the most serious possible way, having pled guilty 8 months earlier to serious felonies in Oklahoma County. This is also despite the fact that Brandy's own ODOC probation officer from Payne County had explicitly recommended that her deferred sentence be accelerated to a felony conviction after she was charged with felony murder in Oklahoma County. When George Burnett was shown the secret cooperation memorandum with Brandy Warden that emerged on the last day of the evidentiary hearing, Mr. Burnett confirmed under oath that that was the prosecution's actual deal with Brandy all along. When I asked Mr. Burnett to explain why he told Tremane's jury that Brandy's deal was for 45 years in prison, when in fact the cooperation memorandum shows that she was promised 35 years in prison, and that's exactly what she ultimately received, Mr. Burnett testified, quote, never underestimate my ability to say something stupid to a jury, end quote. Coleman Givens was also a key witness for the prosecution against Tremane. At the time, Givens had 2 pending felonies in Oklahoma County, one for writing bogus checks and the other for false declaration of ownership to a pawnbroker. In December 2003, just months before Tremane's death penalty trial the following year, Mr. Burnett intervened into both of Givens' pending felony cases and arranged to have them postponed until after he testified against Tremane the following spring. And then, just 2 months after Tremane was sentenced to death, Mr. Burnett entered a plea agreement with Mr. Givens in which he dismissed one of Givens' pending felonies completely and then downgraded the other felony to a mere misdemeanor with a 1-year deferred sentence. At Tremane's trial, however, prosecutors explicitly solicited Givens' false testimony that he was receiving, quote, no help from the prosecution in his felony case in exchange for his testimony against Tremane. And that simply was not true. The prosecutors delivered on their promise to Givens after Tremane was sentenced to death, dismissing one of his felonies and downgrading the other to a misdemeanor just months later. Despite this compelling objective evidence proving that the prosecutors in Tremane's case lied to the jury and hid from Tremane and the jury the benefits that they provided and promised to their witnesses as incentives for testifying against Tremane, Oklahoma County District Court Judge Susan Stallings denied Tremane's claims in May of this year. And then just last week, an email between Judge Stallings and Fern Smith about Mr. Wood's case came to light in Richard Glossett's case, where there was a hearing to recuse Judge Stallings from presiding over Mr. Glossett's retrial for first-degree murder. In that email, Judge Stallings personally sends Fern Smith a copy of her order in Mr. Wood's case absolving Ms. Smith of misconduct, telling her, quote, thought you would like to see the order, end quote. They celebrate that decision together, with Ms. Smith telling Judge Stallings, quote, thank you so much, amazing. I don't know when I've seen a more thorough analysis and well-reasoned opinion, end quote. Judge Stallings responds to Fern Smith, quote, which I can't take credit for, it's the proposed findings from the Attorney General's office. They did do an outstanding job, end quote. Meanwhile, earlier this summer, while the Court of Criminal Appeals was deciding whether Tremane deserved a new trial based on the prosecutor's misconduct in his case, Attorney General Drummond emailed the presiding judge of the Court of Criminal Appeals to accuse Tremane behind our backs of, quote, ongoing criminal activity in prison, end quote. In the Attorney General's ex parte email to the court, he asked the court to postpone setting Tremane's execution date until the investigation into his criminal activities in prison was concluded, and so that the results of that investigation could be used against Tremane in these very clemency proceedings. After initially entertaining Attorney General Drummond's ex parte request, Judge Lumpkin reminded the Attorney General that ex parte communications are improper. Judge Lumpkin also informed the Attorney General that if he wanted to present a matter to the court, the proper way to do that would be by filing that request under seal. Attorney General Drummond declined that offer, instead informing Judge Lumpkin that he didn't want to, quote, tip off Mr. Wood that this investigation was occurring or provide us with notice so that we would have the ability to respond ahead of these clemency proceedings. So the evidence in this case is simply overwhelming that Tremane's death sentence is the product of a fundamentally broken system. Over the years, Tremane has pursued relief through the courts, the state and federal courts both, all of which have denied relief either because he couldn't overcome the high relevant legal standard or a procedural bar. In fact, every step of the way, the Attorney General's office has urged the state and federal courts to find Tremane's constitutional claims waived, procedurally barred, both, or to find that he was unable to overcome the exceedingly high bar to federal review of his claims under the Anti-Terrorism and Effective Death Penalty Act. And that's what the courts have done. This board alone has the power to intervene to correct the manifest injustice that would result if Tremane is executed. It's unencumbered by the legal standards and the stringent procedural bars that so far have prevented the courts from granting Tremane the relief that justice requires. Finally, the Attorney General's office has spent a lot of space in their clemency packet portraying Tremane as a threat to public safety because he has been written up for cell phones, has dealt drugs in prison, has gang affiliations, and has also had serious lapses in judgment, including by arranging to have the person who murdered his 21-year-old cousin, Jai Gilbert, by beating her to death, beaten up himself. There is no question that Tremane has made poor choices throughout his time in prison, choices that he's not proud of, and that he's going to take responsibility for today and own up to, and in that way also set an example to the young people and to his family who are in the room about the importance of taking responsibility for and owning your mistakes. But none of the things that the Attorney General's office is accusing Tremane of doing carries a death sentence. And the prison and the criminal justice system are capable of holding Tremane accountable for the things that he has done wrong. That does not change the fact that Tremane never should have been on death row in the first place. And his death sentence is the hallmark of a broken system. To support the pursuit of Tremane's execution, the Attorney General's office has included screenshots from Tremane's messages with others that were curated by the Attorney General's office to portray Tremane as a one-dimensional person who is beyond redemption. What they didn't show you, even though they had access to all of this data, are the messages in which Tremane is looking for strategies to boost his energy, where he's talking about taking his first college exam, where he's talking about trying to keep his mental health strong, where he others, he'll help them however he can. Where he's helping someone stay motivated and buying diapers and baby formula for his grandkids. Where he talks about trying to pour his soul into music to cope with the isolation. And where he talks about how that isolation has impaired his ability to function. Where he talks to a young person about breaking the cycle of violence and warns them against the dangers of gangs and being manipulated by their big homies. Where he encourages people to stay positive despite life being hard. And where he talks about trying to be the best version of himself despite his very real struggles. That is who Tremane Wood is. This board has the power to intercede to correct the miscarriages of justice in this case. Tremane's execution would serve no purpose other than to compound the suffering of those whose lives he's touched. Thank you.
You have some of the witnesses.
Yes, we have other witnesses. Cindy Birdwell will say next.
To the Pardon and Parole Board, I thank you for this opportunity to speak on behalf of Tremane Wood and tell you about the person that I know. As was stated earlier, his original defense lawyer, in his negligence in representing Tremane, did not reach out to me or to anyone I'm aware of who could have added to the true Tremane story. I so wish I had had that opportunity. My name is Cindy Birdwell, and I was Tremane Wood's 6th grade language arts teacher at Stillwater Middle School. It is somewhat unusual for a teacher to stay connected to students as the years and miles separate them, but Tremane was different. He will always stand out in my memory as an active, bright-eyed, yes, sometimes ornery little guy who always wanted to be in on everything. He was in my daughter's class at school, and she remembers him as a kid who liked to draw horses with her friend Julie. I also remember him as a kid who would just hang around my desk a little more than some of the other kids. He was chatty, mischievous, athletic. He had friends. He was very smart and a good writer. His penmanship, as you can see in his letters to me, was and still is amazing and very unusual for a kid his age. One of my sweet memories of Tremane that was the year that he gave me a handmade Valentine on Valentine's Day that was almost as tall as he was. Over the years, with classroom moves and house moves, I've lost that card, or I would have brought it with me today to show you what a sweet child he was and how he went the extra mile to show his caring spirit to me that day. I'll never forget it. Since that time, I have learned that Tremane came to school carrying a lot of pain that a little boy should never have had to carry. He was a victim of abuse, sexual, physical, emotional, and I never knew. I have spoken to his teachers from that time, and they too missed it. I have carried such guilt about that. I visited Tremane in McAllister, and the first thing I said to him was, I am so sorry, Tremane. I am so sorry that I didn't see your pain and tried to get you relief from that pain. He just looked at me with his kind eyes. He smiled and said, that's all right. He said that school had been his happy place, the place where he felt safe and happy, and that he could forget his pain during the school day. He forgave me, but I can't seem to forgive myself. I have spoken to as many of his teachers as I can find, and they all say the same thing. He was active, smart, ornery, 12-year-old boy. Stillwater Middle School had a behavioral issues class for kids who exhibited behaviors that would not allow them to be in a regular classroom. I spoke with that teacher. He was not in that class. Did I have to discipline Tremane when he got too chatty or excitable? Yes. Did he have to have some time out outside the classroom from time to time? Yes. Was he the only one? No. Have you ever been in a 6th grade classroom? We would have little dances at Stillwater's Community Center occasionally, and Tremane loved to come to those. Now, to call these a dance was a stretch. They were more like 12-year-olds running in circles and laughing to some teacher's playlist on a cassette tape, but they were fun. My husband and I and other teachers would chaperone these events. We were very careful not to let anyone in who wasn't a middle schooler, so the kids would have their own space to have fun. I remember Tremane's older brother, Jake, trying to get into those dances. Jake had a reputation as a troublemaker, and I always worried about Tremane's being influenced by him. Jake was totally different from Tremane in behavior and disposition. Some of the men chaperones would have to take Jake into the parking lot and ask him to leave until the dance was over. It was always a tense situation, and Jake never took it well. When he realized he wasn't getting in, he would then demand that we go get Tremane and make him leave the party and go with him. Tremane's face would be so sad when he had to leave, but he was always under the influence of his older brother to Tremane's detriment. I lost track of Tremane after that year, but I never forgot him. When I read in the paper that he was on death row, my heart broke, was shattered. It broke because I knew he didn't belong there. Something must have happened, a miscarriage of justice of some kind, and I was right. The system had failed him again. The Tremane I knew could not have killed another person. I felt compelled to reach out to him, so I wrote him a letter. I have his beautifully written, heartbreaking letters. I gave them to his attorney. The beautiful penmanship and literacy shown in these letters are unmistakably Tremane Wood. We exchanged letters back and forth until he explained that we could use email through a program provided to inmates. I sent him books from time to time, talked about the class he was taking at Rose State, in which he made an A. No surprise there. As a Christian, I felt it important to ask him if he was a follower of Christ. I will never forget his answer. He said, "I've never been a religious man, Mrs. Birdwell, but I'm not a stupid man either. I know there is something bigger than myself." What a powerful, raw, and truthful response. And please note that this grown man has never been able to call me by my first name. He is always that little 12-year-old talking to his teacher with respect and civility. When I visited him at McAllister, I experienced something that I never thought I would experience. There we were in a room full of people with their loved ones and family laughing and talking about life. Tremane was so concerned that I was going to have to buy him lunch out of a vending machine with my own money. I assured him that I was honored to take him to lunch, so we spent the next few hours playing cards, eating packaged chickens and waffles, and drinking sodas and catching up. He asked about my daughter and son, and we talked about his children and his grandchildren. He has the same worries that any parent would have for his kids and grandkids. He even has more concern as he has seen now how being in the wrong place at the wrong time with the wrong people can alter a life in a heartbeat. Our time was too short, but I treasured that time we had together. As I was leaving, I was able to give him a big hug, and I turned to the guard at the door and I said, "Please take care of him." And the guard said without a moment's hesitation, "I will. He's one of our good guys." I sensed at that moment that this guard, who had seen the worst of the worst, knew that Tremane was different. Now, I'm not an attorney. I can't discuss what I know of the law. His legal team will do a good job of that, but I do know that Tremane was a troubled young man in his 20s who had lived a life of abuse and turmoil, who had been failed by the system time and time again, was at the wrong place, at the wrong time, with the wrong people. He was failed by a completely incompetent attorney who admitted as much in a handwritten note to Tremane. He did not kill anyone, and that has been proven time and time again. Science will tell us that the brain is not even fully mature until the middle to late 20s, yet Tremane in his early 20s was put on death row with no support, no hope for redemption. I want us all to take a moment to ask ourselves how we would react to that soul-crushing situation. What would we do to survive mentally and physically? Tremane's resiliency constantly amazes and inspires me. It is time for the state of Oklahoma to do right by Tremane Wood. He has been failed by the system all his life. He has made mistakes, big ones, but none that warrant the death penalty under any law. Please do the right thing and grant clemency for Tremane. Please give him a chance at a life surrounded by his loving support system and family. He has paid for his devastating choice to accompany an older brother on a robbery with more than 2 decades of his life. Now he has a chance for redemption in the second half of his life. Thank you.
Brooklyn will be the next witness.
Good morning. My name is Brooklyn Wood. I am 17 years old and Tremane's niece. I came here today to talk to you about my uncle and how much he's been an anchor in my life. I would like to start by saying my uncle means the world to me. He's the most amazing role model, and you probably wouldn't think I would be saying someone on death row was a role model to me because the news and media has painted my uncle to be such a monster. But my uncle has helped me through multiple mental health crises throughout the years. I used to struggle with self-harm and severe depression. My uncle helped me pull out of that. My uncle has also helped me through losing my dog, who was my best friend and which devastated me. His shoulder was the one I leaned on during that time. I've always gotten bullied really bad by other girls, and my uncle has taught me how to deal with it by ignoring the bullies even when I was at my wit's end. He has also taught me that my worth isn't measured by what other people say about me. My uncle has always understood me in a way others never did. We're both outcasts. He understood what it's like to be the black sheep, the person that was always in trouble, or someone that was always frustrated and not knowing how to deal with that frustration. My uncle guided me through these things and taught me healthy ways to cope with my feelings and my trauma. He reminded me of my own worth. He encouraged me to surround myself with positive people who can help support me. My uncle has always been an amazing man. Not a perfect man, but an amazing, loving, caring man to me. And so many others. We've grown a lot closer in these past 4 years. I've never been felt more understood by a person. My uncle's helped me through my aggression, and when I would fall behind in school, he'd always tell me, Brooklyn, you have the way to make a difference. You can't make a difference if you're sitting here falling behind. He always told me just because you take a step back doesn't mean that's a bad thing. It's just because God didn't think you were ready for it yet. He's always been an amazing uncle, and I can never stress this enough. Every person you talk to will have something amazing to say about my uncle, whether that be a memory, a word of advice, or just a kind gesture he's done. When it comes to our family, our uncle is definitely a bright light. His relationship with my brothers and sisters have always been good. He's helped my brothers through school and helped him through arguments and differences with my mom and dad. He's also been amazing with my sister. He's helped her through school as well and helped her deal with disagreements with our grandmother and our father. My uncle is definitely the glue in our family. He keeps us together and from crumbling. You as the Clemency Board have influence, and I can only say so much here to help you learn about our uncle and hope that you spare his life. I always tell people that it's hard to know about death row until you're personally affected by it. All I can ask is for you to put yourself in my shoes, where you're about to lose your best friend and the only person that keeps you up and going in the morning. I always look forward to that one single 20-minute phone call, and sometimes that hour visit on the weekend. All I ask is you, as the Clemency Board, please spare my uncle.
That's the conclusion of our affirmative presentation.
All right, let me check to see if the board members have any questions for you.
Sure. And then we might switch out to have members of the legal team also join. I don't know, Kyle, how you want to do that. Should they?
They have questions.
Okay.
Okay. Are there any questions by any of the board members?
Thank you for your presentation. So, one thing I want to make sure that I understand is some uncontroverted matters. One, when Jake took the witness stand in Tremane's trial, part of his testimony was perjury. He lied. Correct?
That's correct.
And he lied about the fact that Tremane was not even present in the motel room when Ronnie Whiff was killed.
That's correct.
And he lied about the fact that Ronnie had absolutely no involvement in the robbery of Ronnie and Arnold.
Yes, that Tremane had no involvement.
I'm sorry.
That's okay. Yeah.
And at trial, it was Tremane's choice to have his brother testify, perjure himself, and testify to what we just discussed.
My answer to that is yes, he did choose to have his brother testify, and at the same time, that choice has to be understood. No lawyer who was coming to see him at the county jail, no lawyer who was talking to him about his defense, no lawyer who was helping him understand what a defense to a capital murder case would entail and working with him to participate in his own defense. So yes, he made that choice, and I would urge the board to see that choice as one born out of desperation and abandonment by his lawyer.
And I don't disagree with you about the performance of Mr. Albert. But you're telling me you think if he had that fully developed understanding of Mr. Albert's theory of the case and how he was going to defend Tremane, that Tremane would not have wanted the opportunity for his brother to lie and completely absolve himself of any involvement in this case?
Yes, I think Tremane would have worked with his attorney with full understanding of the process and what it involved. And in fact, I think it's also possible and likely that if Albert had worked with Tremane, they also might have been able to work constructively with Jake's attorneys as well, to also prevent Jake from getting on the stand to tell a story that was only half true.
So, would you agree that the decision, as I understand the record, Mr. Albert was advising Tremane not to let his brother come essentially perjure himself. Is that correct?
Yes, Mr. Albert in the middle of the trial was advising Tremane of that.
Okay.
And if I could also just add.
Well,
okay.
He advised him of that. And is it fair to say that Tremane's choice to move forward with that, however they got to that point, that probably altered the jury's opinion of Tremane and Mr. Albert and the presentation of their defense?
Well, we know from one of the jurors, Juror Burton, who has testified before the legislature, that she didn't think that Tremane killed Ronnie Whipp. But I would urge the board to also understand Tremane is 24 years old at the time he's going to a death penalty trial with a lawyer who has effectively abandoned him. Albert had no witnesses prepared to present in his defense.
You're way off my question at this point.
Okay, I'm just trying to also put your question in context around his decision.
I've read all of this, and I understand the context, and I'm not disagreeing that Mr. Albert's performance in this case was underwhelming. But the point is, he involved Tremane in the choice to present this defense, perjured defense, and it was Tremane wanted that, and that, do you believe, had an effect on the jury, how they felt about Tremane and Mr. Albert and the presentation of their defense, that they were putting on lies?
I think that it resulted in the jury disbelieving that Tremane was involved in the robbery, yes.
Okay, all right. So, uncontroverted, there was the pizza delivery, the pizza establishment robbery earlier in the night.
That's correct.
Tremane and Jake were both involved.
That's correct.
Jake carried a gun during that event, and Tremane carried a knife during that event.
That's correct.
Then the robbery of Ronnie and Albert.
Arnold.
I'm sorry. The robbery of Ronnie and Arnold. Jake and Tremane enter the room armed.
That's correct.
Each with one weapon.
That's correct.
Jake with a gun.
Yes, that's right. Mm-hmm.
And Tremane with a knife.
That's correct.
And while Jake was robbing Arnold at gunpoint, Tremane was engaging with fighting Ronnie.
That's correct.
Is there any evidence that Jake did not have the knife during that engagement with Ronnie?
Any evidence that Jake did have the knife?
I'm asking, is there any evidence, if he entered the room with a knife, is there any evidence during that fight that he no longer had the knife?
Yes, there is, and it's his slide-bite injury to the web of his left hand. Jake was right-handed. Arnold testified that when the larger man entered the room, he was holding the gun, pointing it at him with his right hand, but we also know that Jake suffered a slide-bite injury to the web of his left hand, which likely was caused when the slide of the gun jammed when it failed to eject a shell casing. And so that is evidence that if he's trying to discharge a gun and has improper grip such that he sustains an injury to his non-dominant hand, why is that? Perhaps his right hand was tied up, struggling with Ronnie over the knife on the bed before he was stabbed.
And so you're supposing because there was one shot fired in the motel room that night,
Yes.
correct?
Yes.
That's
No shell casings were recovered from the scene.
okay, but there was a shot fired.
Yes.
And you got further evidence that Jake was the one that fired the gun because of the injury to his hand.
Yes.
All right. You're making the logical leap that the only thing in his right hand could have been a knife.
Not the only thing. I was just responding to your question. Is there some evidence supporting that Jake may have had the knife at some point during this struggle? And that's what I would point to, that the slide-by injury to his non-dominant left hand would be some evidence of that.
Okay. So that then your conclusion is at some point when both Jake and Tremane are fighting with Ronnie, in the middle of that, they decide to hand off weapons.
Right.
Right.
That Jake, at some point in this struggle, assumed control of the knife from Tremane.
What would be how in the middle of this fight with Ronnie does that make sense? That they're fighting with Ronnie, but they're deciding to hand off weapons back and forth from each other in the middle of that. How does that make sense?
Well, Tremane will talk to you today about this as well, but he has said that when Jake entered the room, pointing the gun at Arnold, demanding money, he approached Ronnie with the knife, and Ronnie grabbed the blade. This is consistent with cuts on Ronnie's hand. That shocked Tremane, that he grabbed the blade with his bare hand, and he proceeded to struggle with Ronnie over control of the knife in the motel room near the bathroom area. Arnold testified that after the larger man robbed him of money at gunpoint, the larger man went over to where the smaller man was struggling with Ronnie. Now, Arnold also said he saw blood coming down Ronnie's hand, which is consistent with Tremane's account that Ronnie grabbed the knife by the blade. Arnold also testified that after the larger man came over and assumed control, or went over to help the larger man, the smaller man came over and hit him with what he thought was the handle of the knife. But he couldn't say for sure to the police that it was the handle because he didn't see a blade. Well, what we know from the state's evidence is that that knife had a sheath. It's in the trial exhibits, and what Tremane has explained was that he had the sheath of the knife up his sleeve, and that's what he used to hit Arnold over the head. So at this point, Jake has control of the knife and is struggling with Ronnie on the bed.
So is there anywhere in the record about the evidence of the sheath being used to strike Arnold on the head?
The evidence in the record it's not in the court record because Johnny Albert didn't do a good job or any investigation. The police interview of Arnold that occurred the very same day the crime occurred includes Arnold saying, the smaller guy came over and hit me with the handle of the knife, but it might not have been the knife because I didn't see a blade. And then there
That
wasn't
my question, ma'am. My question is the evidence that you just told us, this is the first time I've heard that potentially a sheath from Tremane's shirt sleeve was the object that was used to tap Arnold on the head.
Yeah, because
Is that in the record anywhere?
No, because Albert didn't put it into the
That's
record.
my question.
Right.
That's my question.
But there is in the record in the state's trial exhibits evidence that this knife did in fact have a sheath.
Okay. Last question. We have very limited pages of transcript from Jake's trial. At any point in time, was the jury in Jake's trial allowed to know that the same prosecutors who prosecuted Tremane advanced the theory in Tremane's trial that he was in fact the person that killed Ronnie?
I don't believe the jury in Jake's trial was allowed to know that.
Thank you.
Sure.
Are there any questions by Ed?
You said, Counselor, that this is the only, thank you, Sean. You said, Counselor, this is the only felony murder defendant on death row?
The only felony murder defendant for whom there were not findings made that he killed or intended to kill.
All right. And both Jake and Tremane were exposed to the death penalty during jury deliberations, correct?
That's correct. Sure.
I have a question. You talked about the two female witnesses that the prosecutors didn't divulge the deal. Is your statement today that they misrepresented the facts in exchange for that?
Exactly.
So what specifically did they testify to that was inaccurate? I understand they should have told the truth about what the deal was. I understand the inference you're talking about as far as the prosecutor, but did those two females get on the stand and tell something that was not accurate?
So just to clarify, so the deals involve one of the female co-defendants, Brandy Warden, and someone named Coleman Gibbons, who is not a co-defendant. So yes, what Miss Warden told the jury was an account of the crime that minimized her own participation in orchestrating this robbery. Miss Warden blamed her co-defendants, including Tremane, for bullying her, manipulating her, grabbing her face, telling her to suck it up like a big-ass baby. She told the jury that Tremane manipulated and sucked her into this crime as opposed to it being the product of her own choice. The prosecutors used the fact that Miss Warden was manipulated by Tremane into committing this crime to argue to the jury for why he should be executed, because she's one of his victims too. He's ruined her life. He manipulates women. He's a threat, and so the way that Miss Warden's testimony came out during the first stage and the penalty phase really directly advanced the state's case for why Tremane should die. And if the jury had known, well, Miss Warden actually had a prior felony in another county with a co-defendant who she blamed for forcing her to go along, when she's the one who went into the residence, stole the property, including a gun, that could have been used to impeach those aspects of her testimony that minimized her role and aggravated the state's case against Tremane, which then supported the death penalty for him.
I understand. Okay, thank you.
And then Mr. Givens, you had also asked about what Mr. Givens was also a critical witness for purposes of identifying Tremane as the participant in this robbery, because the robbers were masked. And so it was important for the state to show the jury that this person is the one who was involved. So Coleman Givens was staying at a motel across from the Ramada Inn on the night of the crime, and he testified that he heard black voices approach the motel room door. And so the fact that Mr. Wood is black, was also a piece of the puzzle that allowed the state to put Tremane in this robbery. Mr. Givens was also locked up with Tremane and his brother in the county jail before he testified. And Mr. Givens testified at Tremane's trial that when he heard Tremane speak, it sounded like the voice that he'd heard on the night of the robbery.
But real quick, it sounds like he was right. Tremane was there.
Absolutely.
So he didn't lie.
Absolutely, no, he didn't lie. But it's also just the fact that this was a witness who was important to the prosecution's case, and the jury was entitled to know the benefits that he was getting in exchange for helping the state's case.
Thank you.
Is there any further questions? Okay. Well, thank you. We'll go ahead and excuse this time, and then we'll call you back.
Thank you.
You're welcome. Okay. The board will now hear from the state of Oklahoma. Everyone will exchange chairs, then we'll get started. chairs, let's go ahead and take a 5-minute break.